How to make a lasting power of attorney in Singapore. You've been making decisions for yourself, like what to eat and where to live, what to spend your money on, and many other things. But what if you lose mental capacity, which is your ability to make and communicate your own decisions someday? Have you ever imagined falling into a coma after an accident? Or diagnosed with mental illness like schizophrenia, where you lose sense of reality? Or developing dementia, where your mental abilities such as memory, logical reasoning, and other thinking skills have declined severely enough to affect your daily life? What was once thought was old people's disease, dementia is increasingly affecting younger adults who are below age 65. People who are as young as 40 years old can develop what's called young onset or working age dementia. You may already have a will, but it can only be activated once you pass away. So who can manage your assets and affairs when you're still alive, but unable to make decisions? This is where a lasting power of attorney, LPA, comes into play. LPA is a legal document that lets you, the donor, to appoint one or more persons called donees who will make decisions and act on your behalf if you lose mental capacity one day. There are two types of LPA in Singapore, Form 1 and Form 2. Form 1 is a standard version with mostly checkboxes. It is for donors who want to give donees general powers with basic restrictions and can appoint up to 2 donees and 1 replacement donee, in case for any reason one or both main donees can't carry out their duties. Donees are given powers to manage 2 areas, personal welfare and property and affairs. Some examples of personal welfare are your daily routines such as washing, dressing, and eating, healthcare and medical treatment decisions, where to live, and who you may have contact with. And some examples of property and affairs are your property and your money, such as bank accounts and bill payments. Form 2 lets you customize your donee's powers or appoint more than 2 donees or 1 replacement donee, like you want more family members to be involved, or you have specific instructions on who to take care of what and how you want to live. For example, you want to have fish for every meal. But note that Form 2 must be drafted by a lawyer. It might surprise you that your family won't automatically have the right to make legal decisions for you when you lose mental capacity. So you can only do an LPA when you have mental capacity. Once you lose it, you're not allowed to do one. If you don't have an LPA, your family will need to apply for deputyship to get the court's approval to be your deputy, so they can make decisions for you legally. The application process is longer, which can take 3 months or more, and is more expensive. The excruciating process could take a toll on your family. A common myth is that a will usually costs thousands of dollars, but it actually costs only a few hundred. Will and LPA cover different aspects, but they often work hand in hand. That's why lawyers who do wills will most likely offer will and LPA packages too, which you can also consider. You can compare will and LPA package prices on Immortalize. Choose your donees wisely and decide what powers to give them. They should be at least 21 years old and people who you trust. And decide if you'll have more than 1 donees, whether they will act jointly or jointly and severally. Jointly means donees have to make decisions together. If one of the donees is unable to act, the joint appointment will be broken off. Jointly and severally means donees can make decisions individually or together. One donee can act without consulting the other donee. Next, get a certificate issuer, who is either a medical practitioner, a lawyer, or a psychiatrist to sign the form. They make sure you are not forced to make an LPA and understand the purpose and powers given to people who are going to make decisions for you. Lastly, submit your LPA application within 6 months from the date you sign on the LPA form. Your application can be rejected if you make common mistakes such as missing or putting incorrect information, or any potential conflict of interest between witness and donees. For example, the witness is the donee, or the certificate issuer is related to the donee, which could delay the process and you'll incur extra costs. You can revoke or cancel your LPA by completing a revocation form. The Ministry of Social and Family Development advised that you should only revoke an existing LPA when you are registering for a new one, so you'll always have an LPA in place for a benefit. At Immortalize, you can easily find, compare, and book an LPA provider instantly at the comfort of your home. Check out Immortalize's website now.